Hello, everyone, and thank you for joining today's webinar. Before we begin, we'd like to cover a few webinar housekeeping items. If you have any questions during the webinar, you can submit your question through the Q&A window. If we do not get to your question during the webinar, our presenters will follow up with you via email after the program. Additional materials are available in the Event Resources window on your console. You can find a copy of the program slides there. A recording of today's webinar will be available tomorrow and will be emailed to you at that time. With that, we'll begin the presentation. Aaron will start by going through our agenda.
Hello, this is Aaron Young and my co-presenter George. We're both New York state tax lawyers. We specialize in state tax litigation in a variety of states. I'm primarily based in New York, also licensed in Pennsylvania. George is primarily based in Philadelphia, but also licensed in New York. So we have some interesting experience, as well as the other lawyers in our group that also specialize in state tax. So for this edition, we're going through sales tax issues, some refund opportunities, some common audit issues. The topics that we identified that tend to get the most controversy in New York include information services, computer software, sort of miscellaneous services, and we'll call them audit issues. And then also there's some proposals that have been circulated regarding the digital environment and taxation that George is also going to address. So we will be taking turns on the various slides and the various topics, and there will be some overlap as well, and we hope you find this webinar helpful and informative. So the first case we wanted to go over was an information services case. So information services in New York is a hot topic. It has been for years. New York is one of those states that imposes sales tax on information services. And there is an exemption in New York where those services are not taxable if they are personal and individual in nature. So you really have two issues. You have the issue of, is it an information service? And if so, is it personal and individual in nature? And you find litigation and controversy around those two issues primarily. So one of the most important cases on information services in New York came out recently, 2019, the Wegmans Food Markets case. That was a case where there was a service provider who was surveying pricing in supermarkets and putting together information for Wegmans on whether their pricing was competitive and whether their marketing from a price perspective was successful or could be improved upon. And the question was, considering this was information just for Wegmans and that it wasn't shared with third parties, would this make it a sort of a non-taxable information service? So it was sort of personal in nature, and that it was just for Wegmans. And what's interesting about this case is the courts in New York focused on the nature of the information rather than how it was customized for the customers for Wegmans use. And because the pricing was public and was generally available to anyone that wanted to sort of browse the aisles at the grocery store to see what the prices were, the information was public, even though the information put together by the vendor was customized and private for Wegmans. And this case went through the administrative tax boards all the way up to the highest court in New York, which in New York is the New York Court of Appeals, where they upheld the assessment on the against Wegmans. In this case, the vendor was not charging tax, and upheld the assessment as taxable information services because the information itself was generally publicly available. So interesting case. If you have an information services matter with the department, this is certainly one case you'd want to review in detail for its analysis. And again, the two issues are, is it an information service? And that's a primary function test, and we'll talk about that a little bit more later. And if so, is it personal, individual in nature? There's several cases in New York. One of the best ones, if your issue is primary function, is called SSOV. It's from the 90s, and it was actually sort of a dating, or, online or remote dating case. And the department attempted to impose tax on that as an information service, and the courts found that the primary function wasn't information; it was in fact, social interaction or dating. And it went through sort of a primary function analysis that was very helpful as well. So those are the two primary issues you want to look at with respect to information services. Something else interesting about the Wegmans case is it also got into an issue of exclusions versus exemptions. And contrary to sort of long-standing precedent, not just in New York but other states, it found that the exclusions from tax would not be interpreted in favor of the taxpayer. And you did find some dissent in the concurring and dissenting opinions, or disagreement with that burden analysis. And that's problematic considering this is the High Court of New York. So something else to think about. So Wegmans is not just an information services case, although that's the primary issue. It also goes into burden with respect to sales tax and exclusions and exemptions. So one more information services thing we wanted to mention, or at least a taxpayer advisory. There was a recent one, June of last year, 2020, where a TSB was issued. A TSB is a document issued by the department in New York, Department of Taxation and Finance, where a taxpayer asks a question and the department determines the question to be sort of relevant enough where they want to publish it. Usually they exclude sort of taxpayer specific information, but if the policy guidance is helpful to the public, they'll issue a TSB. So you'll see these being issued fairly commonly in New York based on taxpayer questions to the department. And this was a digital marketing service question, and whether or not the taxpayer provided an information service or a non-taxable service. So if it's not an information service and it's not an otherwise enumerated taxable service, then you have a non-taxable service in New York, which is how most states handle the analysis. So in this case, the department found, based on this taxpayer's facts, which are outlined in detail in the TSB, that the service itself was an advertising service and therefore not subject to tax, sort of a digital marketing service. However, if software was included in the service, that could cause the entire transaction to be taxable unless the non-taxable portion of the service was broken out into a reasonable estimate. So the digital service was considered to be not an information service. However, the entire service could be taxable as just a license to use software, and that's how the TSB concluded. So for the next slide, I'm going to hand it over to George to discuss matter of market share partners.
Thanks, Aaron. As Aaron mentioned, we'll turn to a case which was litigated by attorneys in our practice group, Market Share Partners LLC. Market Share is a marketing analytics firm headquartered in California with offices in New York. Its business activities included marketing analytics consulting for advertisers and for media companies, an advertising agency product, and sales of white paper research services. The division commenced a sales tax field audit of market share and ultimately determined that the taxpayers' sales of marketing, analytics, consulting, and sales of white paper research services were taxable sales of information services. The division also assessed market share for sales tax on its sales to advertising agencies, which the division claimed was taxable pre-written computer software. Upon review, the administrative law judge, the ALJ, determined that the marketing analytics consulting service that market share provided to advertisers did include the provision of information, but concluded that it was only one component of a larger service and that it therefore didn't make that service taxable as an information service. The ALJ reached the same outcome for the marketing analytics consulting service market share sold to media companies, with the exception of one agreement which was determined to be a taxable information service. Finally, the ALJ determined that the white paper research services were taxable information services and that the advertising agency product was the taxable sale of a license to remotely access pre-written software. This case does provide insight into how taxpayers can successfully show that services they sell are not taxable information services despite the division's attempt to tax them as such. So Aaron will now cover the taxability of computer services.
Thanks, George. So the next topic sort of brings together what we just covered, what George and I just covered regarding information services, non-taxable services, software. The general guidance from the department regarding the taxability of software is found in Taxpayer Bulletin ST 128, which was issued in 2014. So software is broadly taxable in New York, regardless of the medium or media that it's broadcast on or transferred on. It can be transmitted electronically, sort of intangibly. It's still taxable. It doesn't have to be on a disk or intangible format. It's broadly considered to be taxable. So what the department's been doing for years, including prior to this taxpayer bulletin that was issued, is analyzing any kind of electronic service that a New York customer receives. Be it, like the TSB we talked about a minute ago, which was digital advertising services, be it data processing services, pretty much any kind of electronic service. They'll initially review it to determine if it's a taxable information service. If it's not, what the department will then do is typically ask for the service agreements to see what type of language is included in the service being provided. And what you typically find in electronic services is that there is some type of use of software, either remote use or access of or some type of viewing of software just by the very nature of an electronic service. You need some type of connection to transmit the service and receive the service. So typically there's got to be some software involved. So you do see language in those contracts that will address software, even if the primary function, which we mentioned earlier, of the service is not the license of software. But what the department will do, and the auditors will find the provisions in those agreements that discuss the use of software, which are typically in those agreements because the vendor is protecting its intangible and intellectual property, where since someone is using their service and they can at least view how their service is being delivered or structured or formatted, there's typically language in those contracts that talks about software being owned by the vendor, and sort of intellectual property protection type language. The department will take that and determine that there is software involved in the provision of the service, and therefore, if the value of that software is not separately stated on the invoice, and it's oftentimes not because the primary function of the transaction is not the license of software. If it's not broken out separately pursuant to the Taxpayer Bulletin 2014, then the entire charge is taxable. So what typically happens is the auditors will ask taxpayers to, they'll point out the provisions in the contracts and then ask taxpayers to break out the value of the software, which is not broken out because neither the vendor nor the customer considers themselves to be providing or purchasing software. So you'll get the auditor assessing or threatening to assess the full amount of the transaction because you don't have it separately broken out. And the problem with separately breaking it out is that you're then sort of conceding that there is some software component that you're using that is subject to tax, which hasn't been paid or collected. That's kind of the conundrum that many taxpayers will have to focus on or address during an audit of an electronic service. So the answer to that, or the response to that, is that even if there is some software component, the value of that is typically zero because the primary function of what the customer is purchasing is something other than software. So what we've done is handle these issues with auditors by providing either guidance, for example, that the value of the software transferred is zero because all of the value is in the other services, and that the vendor would never separately license just the software without the underlying service, and information like that to attempt to get the auditors to drop the issue of there's some license of software going on here and we want to tax a piece of that. Because again, the downside of breaking out a piece of that is that it would be subject to tax, even if that's not the primary function of the transaction. And there's a lot of guidance in New York, not so much published cases, but more TSBs, taxpayer requests for bulletins and memorandum regarding de minimis software included in a service not being taxable. And that's where you're trying to go as either the customer being assessed use tax or the vendor being assessed sales tax for not collecting. You want to go down the road of the software is de minimis and is not the primary function of the transaction with the customer. And when you look at our slide, that's where we're talking about the embedded software. That's basically what the department is saying, that there's software embedded in a non-taxable service, and we want you to break that out. And that of course there's downsides to that. Another issue with respect to computer software and taxable information services as well is how the software or service is used and where it's used. So we've had several cases where we've had invoices coming into New York that were being assessed by sales tax auditors as either an information service or software used in New York with, I guess, the initial thought that, this is a non-taxable service or it's not the use of software, but rather than having to rely on that argument, you can drill into where the service or potentially software is being used. And even though it's being invoiced to New York, it may be used outside of New York. And that's somewhat common for multi-state and multinational taxpayers, where there's one central location receiving invoices, but the service itself is really being used, by personnel located in another state or another country. And that's why we say, look at the location of the workstation, look at the location of use. And if it's being used in multiple locations, you can apportion the amount of sales tax that would be due. So if the entire invoice is coming into New York, but it's being used at 10 workstations, only one of which is in New York, then only 10% of that should be taxable rather than 100%. And again, this sort of circles back to the primary function analysis too. What's the primary function of the transaction? Is it a taxable information service, computer software, or something else, which would be a non-taxable service? So moving on, one more topic I want to address regarding taxable services. We do see some audit issues pop up every now and then regarding professional services and when those are taxable. So there's several TSBs that we have listed here. And just to reiterate, so a TSB is when a taxpayer requests guidance and it's published by the department. There's also the taxpayer bulletin, like I mentioned in the prior slide from 2014. That's not, the taxpayer bulletins are not a result of a taxpayer asking questions. It's merely the department issuing guidance that it thinks is helpful, sort of on its own without being prompted. For example, when computer software is taxable and how it's taxed is certainly an important question. So the department on its own created a bulletin that it issued. So that's a little bit different from a TSB. But these are TSBs discussing different types of professional services. We've had auditors take the view that certain services were, for example, taxable security services, which are an enumerated taxable service in New York, or taxable home inspection services. Typically, there's licenses that are required for vendors to perform those services, like a security service, or a home inspector is typically licensed, for example. So if there's no professional license associated with the service being provided, then there's a very good position that it's not a taxable service, even though the vendor may be performing a service that is similar in nature to security or home inspections. For example, there's many banks are required to review homes or properties that are in default. And they do that through oftentimes just sort of visual inspections from outside of the home to determine if the home's occupied. You know, is there mail in the mailbox? Is the lawn mowed, et cetera? And those are often called inspection services. However, they're very different from a home inspection service where an inspector would be coming into the home to determine if maintenance is required. So home inspection services are taxable because they typically lead to maintenance, and real property maintenance is a taxable service in New York. But if a non-property owner is getting a property inspected, it's probably not for maintenance purposes. And therefore, even though it's called a home inspection service, it's not necessarily a taxable service like other home inspection services would be that were conducted by the owner. So that's what these TSBs talk about. They also talk about if a particular service is required based on federal or state law, those services could also potentially be exempt because the purpose of the service is to comply with sort of a federal mandate or federal guidance rather than some other primary function. And then finally, the final issue I wanted to mention that can come up with taxpayers in certain industries is food management services. New York has some pretty strict guidance on taxability of employee cafeterias and food management and subsidy type services. And the two primary cases out there are matter of Sodexo USA, and that has to do with if you have a food management company that is performing services for nonprofits such as hospitals or prisons or schools, can the taxpayer claim resale or claim resale to the nonprofit so that it's buying the goods and services being used for the service for resale to a nonprofit, and therefore no tax due on the resale and no tax due on the back end because of the sale to a nonprofit? Or can they claim agency in the fact that they're stepping into the shoes of the nonprofit to purchase the goods and services in the first place, and no tax would be due, sort of at the same level as the resale argument would apply. Stouffer management has to do with and that's an older case from '78, but the guidance is still followed by the department. It has to do with employee cafeterias and subsidies paid and management fees paid. New York takes the view that if a management fee is paid for an employee cafeteria, that is really the purchase of food and is a subsidy for food, which, you know, that's a tax. Hot prepared food is a taxable transaction in New York, like it is in many states. And if there are fees paid for employee cafeterias by the employer, be it a subsidy or a management fee. New York has some pretty strict guidance regarding when that's taxable. So you want to look at, for both of those issues, in Sodexo, you want to see how you're structuring the transactions with the nonprofit to determine if there's a way to either claim resale or agency. For Stouffer, the issue is whether there's a way to structure the management fees or the subsidies such that they're not considered to be part of the meals being purchased by the employees. And again, New York has, I think, more strict guidance than other states regarding those two issues. So changing topics slightly, still on sales and use tax, we wanted to go through briefly the appeal procedure for New York in audits. It's pretty straightforward from a levels perspective, although there's a few major differences compared to other states. So the first issue, or the first, I guess, result of an audit that is being assessed is a proposed audit change document that would be issued where near the end of the audit, where the department would allow taxpayers to discuss sort of issues, whether you agree with certain issues or disagree. Once a disagreement is sort of finalized, you would receive a notice of determination. That's the statutory document that needs to be appealed. So you can't appeal when you merely have sort of proposed audit adjustments. But once you receive a notice of determination, that's an appealable document, and action needs to be taken to sort of protect the taxpayer's rights to avoid collection if the taxpayer is continuing to disagree with an issue. So 90 days to appeal to the Bureau of Conciliation and Mediation Services in New York, BCMS. That's the informal conference board where you typically sit down with the audit team, and it's usually the same auditors that you were dealing with at audit, with maybe some additional higher level tax officials with a comparee who is within the department, but whose sort of goal is to try and mediate a settlement or a resolution at the conference level. If taxpayers determine that they don't want to go to the conference level after the statutory notice is issued, rather than filing within 90 days at the BCMS, they can go directly to the Division of Tax Appeals. That is the record-setting level, more formal litigation. Someone from the New York State Office of Counsel will enter an appearance. You'd be assigned an administrative law judge. There's a petition, an answer, a reply. Typically, there's an evidentiary hearing, or the case is submitted with the documents are submitted on submission, which means there's no evidentiary hearing, but there's still fact-finding in the sense that documents are submitted, and either testimony or affidavits can be submitted as well, stipulations of fact, and eventually, if the case does not settle, there's a briefing schedule and a decision is issued by the administrative law judge. That's the first level where the case can become public. So all of the appeal levels prior to that, the BCMS and the initial filing at the DTA, are not public documents and not available for sort of FOIA, Freedom of Information Law requests because they're considered taxpayer private information. So the first matter that it can become public is a decision by the Division of Tax Appeals and the administrative law judge. The DTA is also the appeal from the conference level. So I mentioned you can skip the conference level and go directly to the DTA. If you don't resolve your case at the conference level, then you have 90 days to appeal to the DTA after an order is issued by the comparee if the case doesn't settle. If you have an order from the Division of Tax Appeals, the administrative law judge, it's not precedent yet. So you will find cases, especially cases where the department doesn't prevail, that are not appealed because it's not precedent until there's a decision issued by the Tax Appeals Tribunal, which is a panel of administrative law judges who review the lower judge's ruling. Those decisions, the Tax Appeals Tribunal decisions, are precedent. And if the taxpayer loses, they can appeal to state court, either the Supreme Court Appellate Division or the highest court, which is the New York Court of Appeals, is the final level. Interestingly, the department cannot appeal from adverse decisions from the Tax Appeals Tribunal. So that's sort of the New York Sales and Use Tax appeal procedure in a nutshell. And with that, I will turn it over to George to discuss some further tax proposals.
Great. Thanks, Aaron. So we're just going to run through quickly some tax proposals that were included in both the executive budget and made in the legislative process. So quickly, in the executive budget, there was a vacation rental tax that was proposed, similar to taxes imposed in other states throughout the country, which would be imposed on vacation rentals and which would require vacation rental marketplace providers such as Airbnb, among others, to collect sales tax on the taxable sales of the vacation rentals that they facilitate, purpose of which is to basically level the playing field between traditional hotels and the growing prevalence of vacation rentals. Next, there was legislative proposals made for digital ad tax, which is similar to those made in other states across the country. We understand that the New York legislator is keeping a careful eye on the status of similar legislation and challenges in Maryland. The Maryland legislation, which was vetoed by Governor Hogan back in May, ultimately was enacted by an override of the governor's veto. Not wasting any time, a lawsuit was filed just recently in Maryland Federal District Court arguing that the law is unconstitutional. So again, our understanding is that proponents of the New York digital advertising bill may wait for the Maryland lawsuit to play out before moving to proceed on this tax. And finally, there's legislative proposal to tax consumer data. Consumer data is broadly defined, definition of which is included on the slide here. The tax would begin at 5 cents a month on the number of New York consumers between 1 to 2 million, and would increase gradually to 50 cents a month on the number of New York consumers over 10 million. And it was clear by the press release by Senator Liz Krueger announcing the introduction of the bill that the target of this proposal is really social media companies and others who collect large volumes of consumer data. So next, Aaron will present this webinar's polling question.
So this is sort of wrapping up the webinar. Thank you for listening. So this polling question is really just for our group's own knowledge. We're sort of curious about what issues, your sort of broad sales and use tax issues that have the biggest impact on your business, and what questions you have or difficulties you have. So the poll options are sales tax collection issues, B, use tax accrual issues, C, computing the proper tax rate considering the thousands of taxing jurisdictions and different sales tax rates in New York or in other states. D, determination of sales tax nexus based on sort of Wayfair and those U.S. Supreme Court case from a few years ago, or none of the above. Yes, you really have other issues that are more troubling regarding sales and use tax audits, and it's not one of the 4 listed options.
Thanks, Aaron. It does look like there were some questions submitted during our presentation, but unfortunately we ran out of time and won't be able to address these questions during the webinar. We will review all questions submitted and will circle back with you individually. Also, please feel free to contact us directly by phone or by email if you'd like to discuss the topics we covered in our presentation today, or if you'd like to discuss any other state tax issues. Our team has more professionals exclusively focused on state tax issues than any other U.S. law firm, and our capabilities cover a wide range of states and issues.